Welcome to Sports Live Media on YouTube. It is you guys, Sports Live, with a political sports update today, May 27th, 2026. This one's going to be kind of a long video, so just bear with me and stuff. The 119th Congress in the 2D session has crafted a bill that is going to be involving college sports. And so I'm going to read the bill verbatim, word for word, on what the bill is, and then y'all can decide what y'all wish to do with it. So, to protect the name, image, and likeness of and provide protections for student athletes and to promote fair competition among intercollegiate athletics and for other purposes. In the Senate of the United States, Mr. Cruz for himself and Ms. Cantrell introduced the following bill, which was read twice and referred to the committee, which is going to go for debate on the floor here shortly. It's a bill to protect the name, image, and likeness rights of and provide protections for student athletes and to promote fair competition among intercollegiate athletics and for other purposes. Hang on, let me go back up. Be it enacted by the Senate and the House of Representatives of the United States of America and Congress assembled. Section 1, short title, table of contents. Short title, this act may be cited as the Protect College Sports Act of 2026. The table of contents for this act will be as follows. Let's see, Title 1, Protections of Student Athletes and Fair Competition, which will include definitions, name, image, and likeness protections, modifications to Sports Agent Responsibility and Trust Act, agent registry requirements for intercollegiate athletic associations, disclosures and establishment of name, image, and likeness agreement database, academic protections, medical coverage requirements, health, wellness, and safety standards, Office of the Student Athlete, Ombudsman, let's see, comparable standards for access to facilities, services, and events, rules governing certain mid-season coaching transitions, student-athlete representation on intercollegiate athletic association governing boards, transfer protections, eligibility to participate in intercollegiate sports, prohibited compensation and agreements, extension of the revenue share cap, commission on the future of college athletics, recruitment and tampering, limitation on liability, private right of action, whistleblower protection, relationship to existing law, neutrality on employee or non-employee status, applicability and severability. Title 2, sports broadcasting. There'll be definitions, limitation on liability for transmission of college sports competitions, requirements for entities selling media rights, market level broadcast across for college football and basketball, prohibition on certain conference mergers or acquisitions, amendments to intercollegiate and interscholastic football contest limitations, media rights utilization requirement for college sports other than football and basketball. Title 1, Protection of Student Athletes and Fair Competition. Section 100, Definitions. In this title, 1, Antitrust Laws. The term antitrust laws has the meaning given that the term in the first section of the Clayton Act, 15 U.S.C. 12, and includes A, Section 5 of the Federal Trade Commission Act, 15 U.S.C. 45, to the extent that such Section 5 applies to unfair methods of competition, and B, any similar state antitrust law, including a state law provision that applies to covering unfair methods of competition having the force and effect of law. Associated entry. The term associated entry means any individual or entity, including a collective that is A, known or should have been known to exist for or act for the benefit of, in coordination with, or at the direction of an institution to promote or support an institution's athletics program or student athletics, including by creating or identifying name, image, and likeness compensation opportunities for institution student athletes. B, An individual or entity that is or was a member, employee, director, officer, owner, or agent of an individual or entity described in subparagraph A. C. An individual or entity that directly or indirectly, including contributions by an affiliated entity, individual, or family member, has contributed more than $50,000 over their lifetime to a particular institution or to an individual or entity described in subparagraph A. D. An individual or entity that has directly or indirectly been directed or requested by an institution or third party acting on behalf of, for the benefit of, in coordination with, or at the direction of an institution to assist in the recruitment or retention of student athletes or prospective student athletes, or otherwise has assisted in the recruitment or retention of student athletes or prospective student athletes. Or E. An individual or entity owned, controlled, or operated by, or otherwise affiliated with the individuals or entities described in subparagraph A. 3. Athlete agent. The term athlete agent has the meaning given that term in Section 2 of the Sports Agent Responsibility and Trust Act, 15 U.S.C. 7801. Collective. The term collective, A, means a person, corporation, booster organization, tax-exempt organization, or other entity that provides donations or other support directly or indirectly to or for the benefit or support of one, a little one, a student athlete who is enrolled or who may enroll at an institution, or little I, 2, the intercollegiate athletics program of any booster organization of an institution, and B, does not include, little 1, an immediate family member of a student athlete or an individual or entity that, big 1, licenses trademark rights of an institution, and Roman numeral 2 does not, double A, small double A, license name, image, and likeness rights of student athletes, or double B, make payments earmarked or designated to fund name, image, or likeness, or other payouts to student athletes. 5. Compensation. The term compensation, A, means any payment, remuneration, or benefit provided to a student athlete or a prospective student athlete, and B, does not include, little I, grants in aid, double I, federal Pell Grants provided under Section 401 of the Higher Education Act of 1965, 20 U.S.C. 1070A, or any other federal or state grants unrelated to and not awarded with regard to participation in intercollegiate sports. Little I-3, health insurance and the cost of health care funded by an institution, intercollegiate athletic association, or conference. Little IV, disability and loss of value insurance, including disability and loss of value insurance, funded by an institution, intercollegiate athletic association, or conference. Little V, career counseling, job placement services, or other guidance available to all students at an institution. Little VI, hourly wages and benefits for work performed outside of participating in intercollegiate sports at a rate commensurate with the prevailing rate in the relevant state or locality for similar work. VII, little, enhanced education benefits including academic awards. VIII, in little letters, financial literacy or tax education resources, or little IX, any program to connect student athletes with employers and facilitate employment opportunities if 1. The financial terms of such employment opportunities are consistent with the terms offered to similarly situated employees who are not student athletes, and 2. Such program is not used to induce a student athlete to attend a particular institution. 6. Conference. The term conference means any organization that is not an intercollegiate athletic association and that A, has 2 or more institutions as members, and B, arranges championships for intercollegiate athletic competitions or sets rules for intercollegiate athletic competition. Cost of attendance. The term cost of attendance, A, has the meaning given that term in Section 472 of the Higher Education Act of 1965, 20 U.S.C. 1087, and B, shall be calculated by the Financial Aid Office of an institution applying the same standards, policies, and procedures for all students. 8. Grant in aid. The term grant in aid means A, a scholarship, grant, stipend, or other form of financial assistance, including the provision of tuition, room, board, books, or funds or fees for personal expenses that, little 1, is provided by an institution to a student by the undergraduate or graduate education of the student, and little I-2, is an amount that does not exceed the cost of attendance for such students at the institution, and B, does not include compensation paid to a student athlete. 9. Image. With respect to a student athlete, the term image means a picture, video, computer-generated representation, or other depiction that identifies, is linked to, or is reasonably linked to the student athlete. 10. Institution. Except as otherwise explicitly provided, the term institution has the meaning given the term institution of higher education under Section 101 of the Higher Education Act of 1965, 20 U.S.C. 1001. 11. Intercollegiate Athletic Association. The term Intercollegiate Athletic Association, A, means any organization, not-for-profit, corporation, association, or any other group organized in the United States that sponsors or arranges intercollegiate athletic competition between institutions. Little 2. Set common rules, standards, procedures, or guidelines for the administration of intercollegiate athletic competition. Little 3 is composed of 2 or more institutions or conferences that are located in different states or participate in intercollegiate athletic competition in more than one state. And Little 4 is not a conference. B includes the National Collegiate Athletic Association and any other national intercollegiate athletic association. And C does not include a corporation, association, or other group affiliated with professional athletic competition. Intercollegiate athletic competition. The term intercollegiate athletic competition means any intercollegiate sport, contest, game, meet, match, tournament, regatta, or other intercollegiate sport event in which student athletes or varsity sports teams compete. Intercollegiate sport. The term intercollegiate sport means a sport played between institutions for which eligibility requirements for participation by student athlete are established by an interstate intercollegiate athletic association and does not include a recreational, intramural, or club sport. Likeness. With respect to a student athlete, the term likeness means a physical or digital depiction or representation that identifies, is linked to, or is reasonably linked to the student athletes, including the uniquely identifiable body, physical characteristics, or voice of the student athlete, any other mark that identifies or distinguishes a student athlete, or the jersey number associated with the student athlete during the period of athletic competition or athletic participation by the student athlete at an institution if the jersey number is accompanied by a bunch of things. Go back. Let's see. A logo or color scheme that is clearly associated with the institution, or some other means by which the jersey number is associated with the student athlete. I'm going to keep going with this, and I'm going to just read it word for word. Just keep on with it, so bear with me on this. Name. With respect to student athletes, the term name means the first or last name that identifies the student athlete, a nickname or assumed name of the student athlete, or a username associated with the student athlete on any public-facing internet platform when used in a context that identifies, is linked to, or is reasonably linked to the student athlete. Name, image, and likeness agreement. The term name, image, and likeness agreement means a contract or similar agreement between a student athlete or group of student athletes and a conference, institution, intercollegiate athletic association, associated entity, collective, or third party regarding the commercial use of name, image, and likeness rights to the student athlete or the group of student athletes. Name, image, and likeness rights. The term name, image, and likeness rights means the ability of a student athlete to market and profit from the commercial use of his or her name, image, or likeness. Prospective student athlete. The term prospective student athlete means an individual who is recruited, actively being recruited, or has been contacted for the purposes of recruitment to attend an institution as a student athlete but is not yet enrolled at the institution. Revenue share cap. The term revenue share cap means the benefits pool limit set forth in the injunctive relief settlement agreement approved by the court in R.E. College Athletic NIL legislation number 20 EV 03919, North Dakota and California, June 6, 2025, or is modified pursuant to the amendments provisions specified in paragraph 55 of that settlement. Student athlete. The term student athlete means an individual who is enrolled as a full-time student at an institution and who makes satisfactory progress towards completing a degree and participates in intercollegiate athletic competition or competes for a varsity sports team as part of the institution's educational, developmental, or extracurricular programs. Third party. The term third party means an individual or entity that is not an institution, associated entity, collective, conference, or intercollegiate athletic association. Let's see. Valid business purpose. The term valid business purpose means a purpose genuinely related to the promotion of goods or services provided to the general public for profit. Varsity sports team. The term varsity sports team means a sports team composed of student athletes that is organized by an institution for the purpose of intercollegiate athletic competition. Section 101. Name, image, and likeness protections. Student athlete name, image, and likeness compensation. In general, except as provided in this title, an institution, conference, intercollegiate athletic association, or any representative of such an entity may not restrict the ability of a student athlete group or student athletes or prospective student athlete to market or earn compensation for the value of their name, image, or likeness rights, or to enter into a name, image, and likeness agreement, restrict the eligibility for intercollegiate athletic competition for a student athlete or prospective student athlete on the basis of the student athlete or prospective student athlete entering into a name, image, and likeness agreement or marketing or earning compensation for the value of their name, image, or likeness, unless otherwise required by law. Limit the eligibility or opportunity of a student athlete or a prospective student athlete to apply for or receive a grant and aid, including the amount, duration, or renewal of such grant and aid, on the basis of the student athlete or prospective student athlete entering into a name, image, and likeness agreement or marketing or earning compensation for the value of their name, image, or likeness, or, unless otherwise required by law, revoke, reduce, or decline to renew a grant and aid for student athlete or prospective student athlete based on the student athlete or prospective student athlete entering into a name, image, and likeness agreement or marketing or earning compensation for the value of their name, image, and likeness. Consent and compensation for group use. An institution, conference, intercollegiate athletic association, collective, third party, or any representative thereof may not use the name, image, or likeness of any group of student athletes to sell or promote any product or service unless the institution, conference, athletic association, collective, or third party, as the case may be, obtain an agreement from each member of the group for that purpose. Exceptions. Certain agreements. An institution may restrict the eligibility for intercollegiate athletic compensation of a student athlete or prospective student athlete who enters into a name, image, and likeness agreement that violates the code of student conduct of the institution that applies to all students enrolled at the institution. Certain uses. An institution may restrict the eligibility for intercollegiate athletic competition of a student athletic or prospective student athlete if, in connection with the name, image, and likeness agreement, the student athlete or prospective student athlete uses a facility, uniform, equipment, registered or unregistered trademark, copyright protected product, or the official logo, mark, or other indicia of the institution without the express consent of the institution. Mandatory disclosures by student athletes. In general, all student athletes shall report to their institution not later than 30 days after entering into a name, image, and likeness agreement, the terms of any such agreement that exceeds $600 in value, including multiple payments, remunerations, or benefits from the same entity that exceed a total of $600 over a 12-month period, and to the extent not reported under paragraph A, not later than 30 days after receiving compensation for the name, image, or likeness of the student athlete, the amount and source of any such compensation that exceeds $600, including multiple payments, remunerations, or benefits from the same entity that exceed a total of $600 over a 12-month period. Mandatory disclosures by recruited athletes with respect to a student athlete or prospective student athlete who is recruited to attend but is not enrolled in an institution. The student athlete or prospective student athlete shall report to the institution the terms of any current or ongoing name, image, and likeness agreement that exceeds $600 in value, including multiple payments, remunerations, or benefits from the same entity that exceeds a total of $600 over a 12-month period, and in the extent not reported under subparagraph A, the amount and source of any current or ongoing name, image, and likeness compensation that exceeds $600, including multiple payments, remunerations, or benefits from the same person that exceeds a total of $600 over a 12-month period. Exception. In general, paragraphs 1 and 2 shall not apply to either marketing or earning compensation for the value of the name, image, and likeness rights of a student athlete, or to the compensation within the name, image, and likeness agreement in which a student athlete receives less than $600, including multiple payments, remunerations, or benefits from the same person that total loss than $600 over a 12-month period. Adjustment for inflation. An intercollegiate athletic association shall adjust the amount described in Clause 1 for inflation by the percent increase, if any, in the Consumer Price Index for all urban consumers published by the Bureau of Labor Statistics of the Department of Labor for the most recent 12-month period for which applicable data is available. Release of information. Except as provided in Section 104, an institution may not release any information provided by a student-athlete or prospective student-athlete in a disclosure under paragraph 1 or 2 without the express written consent of the student-athlete, prospective student-athlete, athlete agent, or the student-athlete or prospective student-athlete, or in case of a minor, the parent or legal guardian of the minor. Limitation. This subsection shall apply only to Division I institutions as defined by Bylaw 20.9 of the National Collegiate Athletic Association or a successor bylaw and student-athletes of prospective student-athletes of such institutions. Name, image, and likeness. Compensation by institutions. Subject to the requirements of this title, an institution, intercollegiate athletic association, conference, collective, associate entity, or third party may pay, provide, or facilitate compensation to a student-athlete for the use of the name, image, or likeness of the student-athlete. Right to representation. An institution, intercollegiate athletic association, or conference may not restrict the eligibility for intercollegiate athletic competition or any other event or activity relating to intercollegiate athletic competition or a prospective student-athlete or student-athlete based on the prospective student-athlete or student-athlete having obtained an athlete agent or legal representative. Educational resources regarding this title. An intercollegiate athletic association shall provide student-athletes and prospective student-athletes and the parents or guardians of student-athletes or prospective student-athletes with educational materials relating to this title. Section 102, Modifications to Sports Agent Responsibility and Trust Act. In general, the Sports Agent Responsibility and Trust Act, 15 U.S.C. 7801 at sequence, is amended. In Section 2, 15 U.S.C. 7801, A, in paragraph 5, by inserting before the period the following, and includes any name, image, and likeness agreement as defined in Section 100 of the Protect College Sports Act of 2026, B, by redesigning paragraph 6 through 9 as paragraph 7 through 10, respectively, and C, by inserting after paragraph 5 the following. Intercollegiate Athletic Association. The term Intercollegiate Athletic Association has the meaning given that term in Section 100 of Protect College Sports Act of 2026. 2, in Section 3, which would be 15 U.S.C. 7802, A, in subsection little a, in paragraph 2, by striking or at the end, in paragraph 3, by striking the period at the end and inserting a semicolon, and by adding at the end of the following, enter into an agency contract or represent a student-athlete in a manner that violates Section 9. Charge a student-athlete a fee in connection with an endorsement contract that exceeds 5% of the value of the endorsement contract. 6. Enter any agency contract with an athlete for a term that extends beyond the eligibility of the student-athlete to participate in intercollegiate sport. 7. Make any materially false, deceptive, or fraudulent representations as an athlete agent, including any materially false, deceptive, or fraudulent statement to a student-athlete or prospective student-athlete that misrepresents the existence, nature, or value of a name, image, or likeness opportunity the athlete agent can arrange on behalf of the student-athlete or prospective student-athlete through recruitment or transfer to an institution as defined in Section 100 of the Protect College Sports Act of 2026, or number 8, make a materially false, deceptive, or fraudulent statement in the application for registration as an athletic agent, and B, in subsection B3, by striking warning to student athletic, if you agree orally or in writing to be represented by an agent now or in the future, you may lose your eligibility to compete as a student athlete in your sport. 3, by inserting after Section 515 U.S.C. 7804 the following. Section 5A, Private Right of Action. In general, any current or former student athlete alleging a violation of paragraphs 4 through 8 of Section 3A, Section 9, or Section 10 may bring a civil action in an appropriate district court of the United States or in an appropriate state court. Relief. In a civil action brought under subsection A in which the plaintiff prevails, the court may award a declaratory judgment that a name, image, or likeness agreement as defined in Section 100 of the Protect College Sports Act of 2026 or any agency contract as applicable is null and void. And 2, actual damages. C, attorney's fees and costs in a civil action brought under subsection A, which the defendant is not an institution, as defined in Section 100 of the Protect College Sports Act of 2026. The court may, in its discretion, award reasonable attorney's fees and litigation costs to the prevailing party. Invalidity of pre-dispute arbitration agreements and pre-dispute joint action waivers. 1. In general, notwithstanding any other provision of law, no pre-dispute arbitration agreement or pre-dispute joint action waiver shall be valid or enforceable against a student athlete with respect to a dispute arising under this act. Applicability. Any determination as to whether or how paragraph 1 applies to any dispute shall be made by a court rather than by an arbitrator, without regard to whether the agreement or waiver that is subject or the dispute purports to delegate such determination to an arbitrator. Definitions in this subsection. A. Pre-dispute arbitration agreement. The term pre-dispute arbitration agreement means any agreement to arbitrate a dispute that has not arisen at the time of the making of the agreement. Pre-dispute joint action waiver. The term pre-dispute joint action waiver means an agreement whether or not, or a pre-dispute arbitration agreement that would prohibit or waive the right of one or the parties to the agreement in order to participate in a joint class or collective action in a judicial, arbitral, administrative, or other forum concerning a dispute that has not yet arisen at the time of making the agreement, and by adding at the end of the following. Registration of athletes, agents, and other requirements. In general, an athlete agent who seeks to represent a student athlete in an endorsement contract shall register with the state before representing a student athlete for an endorsement contract. And 2, enter into an agency contract with a student athlete before providing representation in an endorsement contract. Registration established. An individual is deemed to be registered with the state for purposes of this section if the individual is a registered professional sports agent with a professional sports league or players association in good standing, or registered and certified under the All-State Uniform Agents Act in the state in which the agent participates in good standing, or operates rather. Certification to intercollegiate athletic associations. Requirement. An athlete agent that represents a student athlete shall certify to each applicable intercollegiate athletic association that the athlete agent is registered within a state. Prohibition. It is unlawful for an individual to certify to an intercollegiate athletic association that the individual is an athlete agent if the individual is not registered with the state. Requirements for agency contracts. To be a valid contract, an agency contract shall state the name of each party to the contract, state the term of the contract, state the registration information for the athlete agent, and state the fee or of commission charged by the athlete agent. Section 10, endorsement contract requirements. Requirements for endorsement contracts. An endorsement contract made in interstate or foreign commerce is at the optimum of the student athlete, void from the inception of such contract if such contract does not satisfy the following requirements. The contract is in writing. 2, the contract plainly states that the student athlete has the right to obtain or retain an athlete agent or legal representation with respect to the contract. The contract contains a description of services rendered, the name of each party to the contract, the terms of the contract, the amount of compensation to be provided to the student athlete under the contract, a provision specifying the circumstance or event that would result in the termination of the contract due to non-performance of obligations by the student athlete or other parties to the contract, and a provision specifying that the validity and effectiveness of the contract and the provision of compensation to the student athlete under the contract is not conditioned upon any express or implicit requirement that the student athlete enroll or remain enrolled at an institution or reside in a particular location within the United States, unless the party making the contract with the student athlete is an institution, conference, associated entity, or collective affiliated with the institution, and the contract is entered into the student athlete has enrolled at such institution. The contract is not for a term that exceeds beyond the eligibility of the student athlete to participate in intercollegiate sports. If such contract is between a student athlete and an institution, Intercollegiate Athletic Association, conference, associated entity, or collective. Clerical amendments. The table of contents for the Sports Agent Responsibility and Trust Act is amended. 1. By inserting after the item relating to Section 5 of the following, private right of action, and by adding at the end of the following, registration of athlete agents and other requirements, endorsement, contract requirements. Section 103. I know this is a long video, so I'm sorry about that. Let's see. Section 103. Agent registry requirements for intercollegiate athletic associations. Requirements of intercollegiate athletic associations and intercollegiate athletic associations shall maintain a publicly available website that includes a searchable database of athlete agents that are registered with the state and certified pursuant to Section 9 of the Sports Agent Responsibility and Trust Act as added by Section 102, and have certified compliance with all rules and bylaws of such intercollegiate athletic association, including any recruitment and tampering rules adopted under Section 117. Let's see, decertification permitted. In general, an intercollegiate athletic association may decertify or fine an athlete agent for any violation of Section 9 of the Sports Agent Responsibility and Trust Act as added by Section 102 or any violation of Section 117 on recruitment and tampering. Effect of decertification. An athlete agent that is decertified pursuant to Paragraph 1 may not represent or contact a student athlete or prospective student athlete of an institution that is a member of such intercollegiate athletic association. Section 104, disclosures and establishment of name, image, and likeness agreement database. Disclosures by institutions. Let's see. Let me go back. Okay, disclosure of data on name, image, and likeness agreements not later than July 1 of the first year beginning after the date of the enactment of this act, and each July 1st thereafter. Each institution shall disclose to the Intercollegiate Athletic Association in which the institution is a member in an anonymized manner the following data. With respect to each name, image, and likeness agreement disclosed to the institution by a student athlete as required by Section 101B, a description of services rendered, and the amount of compensation to be provided to the student athlete or group of student athletes under the agreement. With respect to each name, image, and likeness agreement entered into between the institution and a student athlete, disaggregated by intercollegiate sports program. The number of agreements the institution entered into, the average value of the agreements, and the total value of the total value of the agreements. Report on revenue and student outcomes not later than 60 days after the date on which an academic year ends. Each institution with one or more intercollegiate sports programs shall submit to the governing athletic association. For such institution, a report that includes for the academic year the following: the amount of revenues and expenditures of each sports program, including the amount of associated entity and third-party donations, federal funds and state funds, including the total amount of remuneration for personnel of each intercollegiate sports program, individually by program and in the aggregate, the average number of hours student athletes spent on intercollegiate athletic events and intercollegiate athletic competition, disaggregated by the sports program, the academic outcomes and majors for student athletes, disaggregated by sports program. Treatment of men and women's programs. An institution shall treat men and women's sports programs as distinct sports programs for the purposes of disclosure and reporting obligations under this subsection. Protection of personally identifiable information. In making a disclosure under Paragraph 1, an institution shall ensure that no personally identifiable information of a student athlete is transmitted to an intercollegiate athletic association. Disclosures by associations and database. In general, not later than September of the first year beginning after the date of the enactment of this act, each intercollegiate athletic association shall establish and maintain a publicly accessible, searchable database for student athletes and their agents to estimate the fair market value for name, image, and likeness agreements. Content of database. An intercollegiate athletic association shall include the data reported by institutions pursuant to subsection A1 in the database described in paragraph 1. Update of database. An intercollegiate athletic association shall update the database described in paragraph 1 each September 1st. Privacy. An intercollegiate athletic association shall take reasonable technical measures to ensure that information available in the database described in paragraph 1 may not be used to identify a student athlete. And I'm going... Limitations. Let's see. Limitation. This section applies only to institutions that compete in Division I as defined by bylaw 20.9 of the National Collegiate Athletic Association or a successor bylaw. Section 108, academic protections. Prohibitions relating to coursework and extracurricular activities. In general, an employee or volunteer of an athletic department of an institution may not exert under pressure over or prevent a student athlete from selecting a course or an academic major of the student athlete's choice. Retaliate against a student athlete based on the student athlete's selection of any course or any academic major, or prevent a student athlete who seeks to secure employment or internships, participate in student groups or events, or serve as a volunteer from doing so unless such activity interferes with mandatory class time or mandatory events related to intercollegiate athletic competition or members on a varsity sports team. 2. Participation in athletic-related activities. In order to ensure each student athlete makes satisfactory progress toward the completion of a degree, each intercollegiate athletic association and any institution that is a member of such association may limit a student athlete to only participate in countable athletic-related activities as part of the educational, developmental, or extracurricular programs of the institution. Rule of construction. Paragraph 1 may not be construed as preventing an institution, an athletic department, or institution or a representative thereof from A, informing the student athlete of academic eligibility requirements and mandatory and expected team activities, or providing other legitimate academic counseling and support services in collaboration with institution to help the student athlete pursue the academic interests of and improve academic outcomes for the student athlete. B, financial literacy and life skills. An institution that offers financial literacy and life skills programming directed to student athletes may not include any marketing, advertising, referral, or solicitation offers in such programming. Scholarship protections. 1. In general, except as provided in paragraph 2, an institution that awards a grant and aid to a student athlete may not revoke, reduce, or condition the grant and aid of the student athlete. A, based on the athletic ability or performance of the student athlete or the contribution of the student athlete to the success of a varsity sports team. B, as a result of an injury or illness based on a physical or medical condition of the student athlete. Or C, roster management decisions. Exception. Exception. In general, an institution may revoke, reduce, or condition the grant and aid of a student athlete or former student athlete who transfers to another institution or does not remain in good standing in accordance with Big 1, the standards of Code of Conduct to the institution applicable to all students, the established athletics program policies for participating in mandatory team athletic activities for a varsity sports team, or the academic standards for athletic eligibility. Notice. An institution shall provide a student athlete with timely written notice with respect to any possible revocation or reduction of or condition on the grant and aid or athletic eligibility of the student athlete. Reinstatement. In the case of a revocation or reduction of or condition on the grant and aid of a student athlete under this paragraph, an institution may reinstate or remove any condition placed on such grant and aid if the student athlete subsequently cures or satisfies the reasons provided by the notice in subparagraph B. D. Former student athletes. In general, with respect to a former student athlete described in Clause 2, an institution shall provide the former student athlete the opportunity to resume study at the institution for the purpose of completing the requirements necessary to earn a degree and the amount of grant and aid the former student athlete received, while previously enrolled at the institution and participating in intercollegiate athletic competition or as a member of a varsity sports team. Former student athlete described. A former student athlete described in this subparagraph is a former student athlete of an institution who 1. Was enrolled at the institution during their last year of eligibility to participate in intercollegiate athletic competition during the preceding 10-year period. 2. Received grant and aid while enrolled at the institution. 3. Was not subject to the revocation of grant and aid under subparagraph A, II, and 4. Has not completed the course of study for an undergraduate degree. Application. This subparagraph applies only to institutions that compete in Division 1 as defined by bylaw 20.9 of the National Collegiate Athletic Association or successor bylaw. Rule of construction. Nothing in this paragraph may be construed to preclude an institution from providing additional grant, aid, and protections for student athletes or former student athletes or an intercollegiate athletic association, conference, institution, student athlete, or former student athlete from requesting or advocating for additional grant and aid protections. Limitation. Subsection C2D shall apply only to institutions that compete in Division I as defined by bylaw 20.9 of the National Collegiate Athletic Association or a successor bylaw. Section 106, medical coverage requirements. In general, each Division I institution as defined by bylaw 20.9 of the National Collegiate Athletic Association or a successor bylaw or an intercollegiate athletic association or conference comprised of Division I member institutions shall provide or cause to be provided during the participation of a student athlete in an intercollegiate sport. All out-of-pocket medical expenses such as co-payment or deductibles for the health care coverage of a student athlete for any injury or disease incurred through participating in an intercollegiate sport. The expense for obtaining a medical second opinion independent of the institution for any injury or disease a student athlete incurred through participation in an intercollegiate sport. Catastrophic injury medical insurance for any injury or disease incurred through participation in an intercollegiate sport that exceeds $90,000 in medical costs, and end-of-college physical examination for a student athlete for the purpose of documenting and diagnosing any injury or condition related to the student athlete's participation in an intercollegiate sport, and for the 5-year period beginning on the date after the last intercollegiate competition for the student athlete, the cost of all out-of-pocket medical expenses of the student athlete for every health care coverage for any injury or disease incurred through participation in intercollegiate sport. Intercollegiate Athletic Association post-eligibility insurance and catastrophic injury fund or program. In general, an intercollegiate athletic association comprised of member institutions that compete in Division I, Division II, or Division III as defined by bylaw 20 of the National Collegiate Athletic Association or a successor bylaw on behalf of its member institutions must establish a fund or program to help cover the cost of A, in the case of Division I, institution that generates less than $20 million in total annual athletics revenue during the preceding academic year, compliance with subsection A2, or in the case of a Division II or Division III institution, voluntary compliance with subsection A2 in the event of demonstrated financial hardship, and B, post-eligibility medical expenses for a member institution student athletes diagnosed with significant long-term conditions related to their participation in an intercollegiate sport, including chronic traumatic encephalopathy and any other cognitive impairment. Amount of fund. The Intercollegiate Athletic Association described in this subsection shall ensure that the fund or program established under this subsection is funded at an amount that totals at least $60 million on the first... Anyway, I'm not going to go over all the other details on that. You get the general idea. It's more just legalese language regarding protections, and it's enhancing more protections regarding the... name, image, and likeness for the college students. That more or less is just a summary of what it covers and everything. So I apologize for the long reading. I somehow lost the bill, I think. No, I didn't lose it. Let me go back through. The amount of fund the Intercollegiate Athletic Association described in the subsection shall ensure that the that the fund or program established under the subsection is funded at an amount that totals at least $60 million on the first day of each academic year. Okay, we'll continue now. Use of collective media rights. In ensuring that the fund or program established under paragraph 2 is adequately funded, an intercollegiate athletic association may use the collective media rights revenue from a covered entity in accordance with Section 5D3 of the Sports Broadcasting Act of 1961 as added by Section 203. Rule of construction. Noting nothing in this section may be construed to preclude an intercollegiate association from providing or causing to be provided to student athletes medical coverage in addition to the medical coverage required by subsection A or exceeding $60 million for the fund or program established in subsection B for any academic year. Anyway, there's more to this and stuff. I've gone through almost half of this document already, so I do apologize for this being a long video. And again, this is basically what is being discussed in the U.S. Senate right now regarding college sports. So, let me continue. Section 107, Health, Wellness, and Safety Standards. Establishment of standards not later than 270 days after the date of the enactment of this act. Each institution, conference, and intercollegiate athletic association shall adhere to standards to protect student athletes from sports-related serious injury, conditions, and death, including brain injury, by adhering to the concussion management practices, protocols, and legislation of the National Collegiate Athletic Association effective January 15, 2024, and is amended to strengthen protections for student athletes. Heat-related illness by adhering to the American College of Sports Medicine expert conscious statement on exertional heat illness, recognition, management, and return to activity, April 2023, and is amended to strengthen protections for student athletes. Let's see, rhabdomyolysis, in accordance with the guidelines of the National Collegiate Athletic Association for exertional rhabdomyolysis, published in 2025, and is amended to strengthen protections for student athletes and for any student athlete who is identified with sickle cell trait by following the guidelines established by the National Collegiate Athletic Association in 2025, and is amended to strengthen protections for student athletes and asthma by following the guidelines of the National Athletic Trainers Association position statement, management of asthma in athletes, September 2005, and is amended to strengthen protections for student athletes. Measures to prevent, assess, and remediate abuse or misconduct. Each institution, conference, and intercollegiate athletic association shall take reasonable actions to prevent, assess, and remediate abuse or hazing of any student athlete, including physical and sexual abuse and sexual assault, sexual misconduct, and sexual harassment. Provision of information or contact for student athlete abusement. Intercollegiate Athletic Association. An intercollegiate athletic association shall provide the student athletes information on how to contact the Office of the Student Athletic Ombudsman as established in Section 108 on the Internet website of the association. Institution. At the beginning of each academic year, an institution shall provide the student athletes information on how to locate the website specified under paragraph 1 or a link to the website and information on how to contact the Office of the Student Athlete Ombudsman as established in Section 108. Athletic Health and Safety Officers. In general, each institution shall designate an employee who is independent of the athletic department as the Athletic Health and Safety Officer for the institution. Reporting. The Athletic Health and Safety Officer designated under paragraph 1 shall report to an employee of the institution who is independent of the athletic department. 3. Officer responsibilities. An employee who is designated by an institution under paragraph 1 as an Athletic Health and Safety Officer shall be responsible for, at a minimum, overseeing implementation of the applicable requirements the institution is subject to under this section, including any applicable training, oversight practices, policies, and procedures, and consulting with student athletes and athletic departments personnel and reporting any suspected violations of this version to the employee specified under paragraph 2. Independence of medical professionals. In general, medical personnel, including athletic trainers, physical therapists, and physicians, shall have the autonomous, unchallengeable authority to determine medical management and return to play decisions for student athletes under their care at an institution. Limitation on non-medical personnel. No coach or other non-medical personnel of an institution may attempt to influence or disregard the decisions of medical personnel with respect to the medical management and return to play decisions for student athletes under their care at the institution. Rule of construction. Nothing in this section may be construed to preclude an intercollegiate athletic association from establishing additional health, wellness, and safety standards to protect student athletes, or an intercollegiate athletic association, conference, institution, or student athletes from requesting or advocating for additional health, wellness, and safety standards to protect student athletes. Section 108, Office of the Student Athlete Ombudsman. In general, an intercollegiate athletic association shall establish an office to support student athletes known as the Office of the Student Athlete Ombudsman. In this section, referred to as the office. Duties. The office shall provide independent advice to student athletes at no cost about the applicable requirements of the title and the amendments made by this title, including with respect to their rights and responsibilities and the resources available. Assist in the resolution of student-athlete concerns regarding the intercollegiate athletic association, conferences, or institutions. Provide independent advice to student athletes with respect to the role, responsibility, authority, and jurisdiction of the intercollegiate athletic association, conferences, or institutions. Provide student athletes with current contact information for external third-party resources for student athletes, and provide independent advice to student athletes with respect to the relative value of engaging legal counsel. Administration. An interstate intercollegiate athletic association shall hire and provide salary, benefits, and administrative expenses for an ombudsman and support staff for the office. Confidentiality. In general, the office shall maintain as confidential any information communicated or provided in the office in confidence in any matter involving the exercise of the official duties of the office. Exception. The office may, with the permission of the parties involved, disclose information described in paragraph 1 as necessary to resolve or mediate a dispute. Application. The confidentiality requirements under this subsection shall not apply to information as necessary to comply with applicable reporting requirements mandated by federal law relating to a felony personally witnessed by a member of the office, if necessary to protect an individual at imminent risk of serious harm, or with the permission of the parties involved as necessary to resolve or mediate a dispute. Judicial and administrative proceedings. In general, the ombudsman and any staff of the office shall not be compelled to testify or produce evidence in any judicial or administrative proceeding with respect to any matter involving the exercise of the duties of the office. Confidentiality. Any memorandum, work product, notes, or case file of the office shall be confidential and shall not be subject to discovery, subpoena, or any other means of legal compulsion or admissible as evidence in a judicial or administrative proceeding. Prohibition on retaliation. No employee, contractor, agent, volunteer, or member of an intercollegiate athletic association, a conference, or an institution shall take or threaten to take any action against a student athlete as a reprisal for disclosing information to or seeking assistance from the office. Independence is carrying out duties. The board of directors or other governing board or committee of an intercollegiate athletic association, a conference, or an institution shall not prevent or prohibit the office from carrying out any duty or responsibility under this section. Section 108, Comparable Standards for Access to Facilities, Services, and Events. Intercollegiate athletic associations and conferences shall maintain comparable standards for medical care, lodging, meals, rest, transportation, and, if applicable, athletic facilities for championship events or tournaments across similarly situated men and women's athletic programs. Section 110, Rules governing certain mid-season coaching transitions. In general, an individual who serves or has served at any point during a competitive season as football athletic personnel for a varsity sports team or intercollegiate football as an institution shall not, during that same competitive season, perform for another institution any duties or responsibilities customarily associated with a head coach or a varsity sports team for intermediate or intercollegiate football, including, at a minimum, recruiting or contacting prospective or current student athletes, directing, participating in, or materially influencing recruiting strategy or evaluations, directing, participating in, or materially influencing roster management decisions, including decisions relating to transfers, facilitating, coordinating, negotiating, or otherwise materially influencing name, image, and likeness activities among student athletes, directing, supervising, or materially influencing coaching staff or team operations, participating in practice, planning, game preparation, strategic decision-making, or in on-field activities, publicly representing the institution in an intercollegiate football level capacity in a manner that reflects or implies authority over the intercollegiate football programs, and undertaking any other activity customarily associated with a head coach or a varsity sports team for intercollegiate football. Anyway, I'm not going to go into this anymore. This is just really long, but you get the general idea of what they're looking to do with this. And there's a lot more information and stuff, and it's a bunch of legalese, and I know a lot of you do not necessarily understand that. So with this reading of part of the bill on the college sports bill that's being addressed by the U.S. Senate, thank you for taking the time to hear about this on Sports Live Media. You can find this on the U.S. Senate and Congress website, and it'll go more into detail on what this includes and what this involves. There's just a lot more information, and it's 111 pages worth, and I've already gone through 50 of them. So, anyway, thank you for taking the time to hear this on Sports Live Media. If you will, please hit the like button, please hit the subscribe button, and please hit the notification bell so you can be made aware of when I'm going over these documents relating to what the Senate is doing for college sports, when I have sports action videos, when I have sports education videos, when I broadcast live, or when I have breaking news in the sports world. Thanks and have a wonderful day.